For our final lecture of the course, we're going to talk about legislative approaches to preventing child sexual abuse. So, obviously, we've talked about many different ways of approaching child sexual abuse prevention, and we know that after the fact, there are legislative initiatives to, incarcerate perpetrators. But how can we use legislative approaches to prevent child sexual abuse? So we really need to think about this through various different legal frameworks. And so we want to try to think about addressing kind of the primary and secondary prevention in our public health model. So before the abuse actually happens, how can we develop laws so that we are protecting children before it is too late? So obviously it's good that we're providing laws for the perpetrators once the crime is committed, but that's too late because the harm is already done. So what can we do on the forefront of that? And so that's what we're going to be talking about today. And we also need to pay attention to kind of as child sexual abuse changes and it's going online, how can we design laws and legislation to protect children online and to criminalize various different behaviors and make sure that that companies that are, tailoring their services to children are adhering to these prevention policies. So obviously, as I mentioned, there are different types of legislative approaches. There's the criminalization and prosecution of child sexual abuse offenses. That is still a relatively new thing. I mean, the last several hundred years. Before that, the age of consent has changed. We even have age of consent laws. And so we're recognizing, throughout history, as time has passed, how horrible, abusing children is, and that we need to hold people accountable, and that children need to be, not seen as sexual beings in order for them to develop appropriately. And so now we have very specific laws. Each state has their own laws, which I think is somewhat problematic. It would be very helpful if we had common nomenclature so that everybody would understand the laws. But laws are in place for all types of child sex abuse offenses. We now have mandated reporting on all, across all 50 states. That means that certain professionals are required to report any reasonable suspicion of child sexual abuse to the authorities and child protective services. Certain states like New Jersey require every citizen to be a mandated reporter. Although mandated reporter training is not always required. That's kind of a more novel thing. So for the people who are mandated reporters, in the last several decades, we've started passing legislation so that they're receiving training on how to be mandated reporters. But if in states where every citizen is a mandated reporter, every citizen does not get training on how to report child sexual abuse. Now, as we talked about when we talked about institutional sexual abuse, those working with children are required to get background checks and fingerprinting, and there are laws that are passed around that. So while before it was considered to be best practice, now, especially in schools, it is required by law, and several states now are passing legislation so that youth organizations also are required by law to have mandated background checks and fingerprinting for those that work with children. There are educational mandates, as we learned about with Aaron's Law. 38 states have passed it, and it requires child sex abuse prevention education in schools. And in the last 5 to 7 years, multiple states have passed look-back windows, as we've learned that disclosure of childhood sexual abuse takes time and that many people don't report in a timely way. They have opened look-back windows so that people who were sexually abused even decades ago are able to engage in civil litigation against those who caused them harm. So this week you had two articles to read about legislative approaches. So the Helping Stein et al. Kind of provided a scoping review of U.S. state legislation on child sexual abuse prevention, and they primarily examined the ones at the primary and secondary level. And then they provided some kind of synthesis of what they kind of found to be the good, the bad, and what really needs to have more work. The biggest thing, and this is the thing that I see consistently across pretty much everything, Each state has autonomy to do its own thing, and so there is a lot of inconsistency across states. I think it is always easier when we have consistent messaging, and that's why I felt strongly, and I mentioned to you this previously, that we need to call sexual grooming because that is how we have defined it, and we have a specific definition. When we have various different laws and legislation across states, it makes things confusing, and so it's harder to implement. Aaron's Law is the most common prevention-focused policy. So as I mentioned, 38 states have that law. And so that mandates child sexual abuse prevention education in schools. We have been looking at what states are mandating, and that varies tremendously in terms of the curriculum. Some states have best practice. Some states will offer websites. Some states offer no guidance at all. And enforcement of Aaron's Law is still not at 100%. And so we really need to think about, again, supporting Erin Marin in her endeavor to have her legislation passed in all 50 states, because all kids deserve that education, but also to make sure that we are doing this consistently in schools. Most policies that we have currently at the state level are tertiary preventions. So after the harm has been done, and so they're really not true prevention. So we've already talked kind of at length about Aaron's Law. It mandates sexual abuse prevention education in public schools. Again, different states have adopted it differently, but it generally should be for children at age-appropriate levels, for parents, as well as for educators. As I mentioned, the content varies, the way that they are administering it varies, and the enforcement of these laws on a state level varies. So while certain states have passed it, the implementation in schools has not really been rolled out yet. So it's something that we want to think about and put political pressure on our legislators about. And I am all for developing kind of, standardized curriculum by experts in the field that really is kind of state of the art in terms of what we know about sex abuse prevention. And you now taking this course are probably, up to date on what we know about the different areas that children need to learn about. I mentioned the look back and civil statutes. So this allows for retroactive filing of child sex abuse claims. So some of them even dating back to the 60s and 70s. These were very much victim or survivor-based initiatives, so that they could kind of get empowerment and healing for what has happened to them, because often historically the statute of limitations elapsed, and so there was really no way, once they were ready to kind of face what had happened to them, that they were able to get any kind of justice. So that's what the civil statutes were about. And when you hold institutions accountable legally, then from a sheer financial perspective, it contributes to them enforcing prevention guidelines so that they're not going to be sued in the future. Other kind of some of the gaps that were identified by Helping Steen et al. Were that very few federal and state laws addressed risk and protective factors before abuse occurred. We're going to talk a little bit about grooming legislation, which is a relatively recent, development, and we really weren't talking much about how to strengthen family issues, targeting at-risk families and community norms. I mean, obviously, when you have the government and the family, that is always a little bit of a scary endeavor. But, thinking about what you learned about incest and sibling sexual harm, what can we do, legislatively, if anything, to, prevent sexual abuse in the home? But I think a lot of it comes down to community norms, and I don't know that we can legislate that, but we do need to change it. And so we want to think about that in terms of prevention initiatives. And currently, as we know, there's legislators give funding for primary prevention. And so, even if they're not passing laws, that they could pass, funding initiatives so that we can engage in more development and evaluation of primary preventions, because that can really be done at the state and federal level. So, their recommendations were to harmonize laws across states for clarity and consistency, develop model policies so you don't have to reinvent the wheel every time. I see that very frequently. Everybody needs to do their own thing instead of looking at what other people have, what has worked, what has not looked. And one thing that I think has been very, very helpful has been incorporating the lived experience of survivors in policy development, because they're the ones that are impacted. I personally think that we can have all perspectives. I think, obviously legislators and survivors, but I think even not at the same table, but, getting information potentially from perpetrators. What were the loopholes that they were able to take advantage of in order to perpetrate the abuse? And then having, people who study this at the table as well. I think all those people can be very helpful in developing evidence-based legislation, and so that it's not just a knee-jerk reaction to, obviously child sexual abuse is a horrible crime, we want to do something about it. But what I see many times is that there are these knee-jerk reactions instead of thinking this through and really thinking about it from an evidence-based policy and what can we glean from, the research, historical cases, etc., so that we can protect kids going forward. So this is an article that we wrote, and there's a book chapter, so that was the one that was, I think, on your reading list, but this is the article that we published in the peer-reviewed journal, where we talked about sexual grooming legislation. And so we've already talked a lot about sexual grooming, and those are the behaviors that happen, before sexual abuse occurs, and a lot of them are observable. And so, and with our red flags, we really feel like we can develop policies, procedures, and potentially legislation in order to criminalize sexual grooming behavior so that we can stop it before it happens. Several states, I know Delaware, Vermont, Texas, have passed standalone sexual grooming legislation. In this article, you'll see that a lot of people call things grooming that really are not, or it happens after, or you have to have the contact sexual abuse, which makes the preemptive grooming legislation kind of irrelevant. It doesn't really matter. Once the contact sexual abuse happens, then it doesn't matter if people participated in grooming or not, unless you want to think about it as an enhancement for sentencing. But when we're thinking about prevention, it's too late. And so this would criminalize grooming behaviors, not just contact sexual offenses. And so we could do that both online and in person. And we've already talked about how we're defining, sexual grooming. And so the definitions have varied across states. A lot of them are targeting only online sexual grooming. I know that's easier because you actually have the transcripts. But we're seeing in person sexual grooming, they often use text messaging, emails, social media, and so we now have records that can be used to prosecute child sexual grooming. And there's obviously concerns about, what if somebody's engaging in normal, healthy mentoring behaviors? We don't want to pathologize that, and we don't want to criminalize that, and we don't want to prevent adults from helping children. So how do we, do that legislatively? What grooming laws can do is they can really disrupt offender behaviors before it escalates to contact sexual abuse. And it provides a legal recourse, even if you cannot successfully prosecute somebody, to charge them with grooming, and for them to be aware that people are recognizing this could be a preventative measure. It also would likely show up on their criminal history. So even if they were not successfully prosecuted, if they were to seek employment within youth serving organizations, it would likely show up on their records. And it would also raise awareness amongst law enforcement and educators so they're more aware of what is going on. However, it is hard to prove intent, and so that's where kind of the research that we've been doing recently would be helpful. There's obviously the risk of criminalizing non-abusive behaviors, which I think gave a lot of legislators pause. And you really need to provide statutory language and guidance to kind of craft the law in a way that can be measurable and that you can help prosecutors and investigators to develop a case in order to show that was happening. Dr. Winters and I were able to testify in Vermont when they were developing their sexual grooming legislation, and they included a lot of the language from our model and from our red flag study in order to to do that. So in terms of school-based prevention, that's where we're seeing the most of these laws. We have passed the trash legislation, which basically prevents schools from letting educators where there have been allegations made against them from retiring or resigning without an investigation. It also prevents, in many states, the ability to kind of not to share, like a lot of states are not allowed to share things from personnel records, only to say that the educator worked there. But this would require them to share that there were allegations of misconduct, because we saw historically, and I think this is where the research and the historical data really becomes important. We saw historically that, educators were allowed to resign when there were allegations against them. There would be nothing on their file, and they would just move to the new school or the new district, and nobody would be any the wiser, and so they would continue their patterns of abuse. What we're also seeing is the criminalization of sexual relationships between teachers and students, regardless of what the age of consent is, as some states have age of consent as low as 16. So when you have somebody in that position of power, that it doesn't matter how old the person is, when that person, the perpetrator is a teacher, that even if they are over the age of 18, that would still be considered sexually abusive behavior. And that really aims to close any loopholes where people in positions of power could use that authority to abuse people, who they have power over. We're also seeing, as I mentioned earlier, these mandated reporter policies and training. And so historically, even though, the mandated reporter legislation was passed for teachers, ranging from the late 60s to the early 80s, a lot of those teachers didn't receive training on mandated reporting policies, especially if they had graduated much earlier in their programs or in their schools. And so now training is also required on a yearly basis so that they can recognize signs of abuse, but also to more broadly incorporate educator sexual misconduct, which was previously not really discussed. And also that people within the organization can be, perpetrators, and how to identify and report that. Some states do extend the requirements to volunteers and contractors in schools and camps. We're seeing this also in youth-serving organizations. And this really, emphasizes early detection and that culture of accountability and child safety, which is what we're really aiming for. And it provides discussions for that. So what we really want to do is to use these laws as a foundation for enforcing policies and practices and creating environments where safety is paramount, and that we have recourses to kind of stop individuals who might be engaging in those preparatory behaviors to harm children before that happens, but also to require people who are looking out for our kids to have policies and procedures in place that we know currently are best practice, and to make sure that they are enforcing them so that those perpetrators can't sneak through and take advantage of non-enforced policies or any loopholes.